Good evening and welcome to the January 14th, 2025 Planning Commission meeting. I'd like to call this meeting to order. My name is Jason Lear and I'm chair of the Eugene Planning Commission. To begin this evening, I'd like to call on Commissioner Beeson for the city's land acknowledgement statement.
Since time immemorial, the Kalapuya people have been the indigenous stewards to our region, building dynamic communities, maintaining balance with wildlife, and enacting sustainable land practices. This land acknowledgement is a way of resisting the erasure of indigenous histories and to honor Native communities by inviting truth and reconciliation. Following treaties between 1851 and 1855, Kalapuya people were dispossessed of their indigenous homeland by the United States government, forcibly removed to the Coast Reservation in Western Oregon. As we consider the impacts of colonization, we also acknowledge the strength and resiliency of displaced indigenous people. The city of Eugene is built within the traditional homelands known as the Kalapuya Ilahi. Kalapuya descendants are citizens of the Confederated Tribes of Grand Ronde Community of Oregon and the Confederated Tribes of the Siletz Indians of Oregon, and they continue to make contributions in our communities here and across the lands. We express our respect for the inherent political sovereignty of all federally recognized tribal nations and indigenous people who live in the state of Oregon and across the nation. Therefore, the Planning Commission recognizes that what we do today will affect the many generations who will come after us.
Thank you, Commissioner Beeson, and thanks to everyone for joining us in this virtual meeting format. Tonight, we're holding a public hearing on an appeal of the hearings official's decision denying a tentative planned unit development and a tentative subdivision to create 39 residential lots, streets, and associated infrastructure improvements for Braywood Hills 3rd Edition. City file numbers PDT 24-1 and ST 24-3. Anyone wishing to access and participate in the public hearing can do so by following the access instructions listed on the agenda for this meeting. Planning Commission meetings can also be viewed by watching the live stream available on our website or the broadcast on Comcast Channel 21. If you wish to speak and provide testimony tonight, please know that we will begin the testimony portion of tonight's meeting after a brief presentation from staff. When we reach that point, staff will provide instructions about the virtual hearing format and how to participate. Before we start, I want to let you know a bit about the Planning Commission and our role in the process. First, we are unpaid volunteers appointed by the Eugene City Council who all live and work in Eugene like many of you. We directly advise our City Council on all matters related to land use, and we're also tasked with making certain land use decisions on behalf of our City Council. We're responsible for upholding the laws of our city and our state, the policies of our City Council, and of course, at the same time, we're also responsible to everyone that lives and works in Eugene. We're at-large members, which means we have to consider the needs of the community as a whole, as well as the needs of all groups and neighborhoods. We're also human beings, which means each one of us has personal views that make us who we are. But as planning commissioners, we're committed to balancing all of our needs as a community and to making the best recommendations we possibly can based on our policies and our laws for us and for future generations. That can be pretty tough to do, and we know not everyone will agree with every recommendation we make. So as we proceed this evening, we want to let you know up front that we're listening, that we care deeply about you and about our community. We recognize how important these changes are and encourage everyone speaking tonight to do so in a respectful and productive way. Given the topic of tonight's hearing, some of the terms we have to use are legalistic, so I'll try to explain the requirements in plain language the best I can. Since this is an appeal hearing for a site-specific application, there are unique procedures which we are legally required to follow. The decision-making process for this application is considered quasi-judicial. We will use a quasi-judicial format for this public hearing. Before we begin, the Eugene Code requires that planning commissioners disclose any conflicts of interest, ex parte contacts, biases, or abstentions. In a quasi-judicial proceeding, the parties are entitled to an impartial or neutral decision maker. To ensure this fair consideration, the Eugene Code and Planning Commission's rules attempt to limit ex parte contacts or communications between a party and the decision maker outside of the public hearing process. Each planning commissioner must disclose and describe the substance of any communication they have had about this application outside the public process. The planning commissioners must also disclose any conflicts of interest, that is, whether the decision they are about to make could or would result in a personal financial gain or loss for themselves, their relatives, or a business with which the commissioner or the commissioner's relative is associated. Finally, a planning commissioner can now participate if they are biased, that is, for whatever reason, they are incapable of making an objective decision on these applications. Do any commissioners have anything to disclose? Does anyone in the audience or a member of the commission wish to challenge the impartiality of any of the planning commissioners? And we'll look to you, Crystal, to see if anyone's got their hand raised.
Yeah, I'm going to lower the current hands that are raised. So if you would like to challenge any impartiality, please re-raise your hand. I'm going to give just a moment for anybody to try to raise their hand. Seeing nothing, I think we can proceed.
Okay. So I'd like to turn it back to you right away, Crystal, to our moderator, provide some important information about tonight's hearing.
Hello, everyone. I'm Crystal Fisher, and I'll be moderating tonight's meeting. I want to thank you all for joining us in this virtual hearing and just remind you that tonight's hearing is being recorded. Since we're meeting virtually and this is a quasi-judicial hearing, I will provide specific instructions on how to request to speak after the staff's brief presentation tonight on the public hearing topic and before the chair opens the public hearing. So with that, it's great to have everyone here tonight, and I'll hand it back to you, Chair.
Thank you, Crystal. As you said, we'll begin with a brief presentation from Nick and then move on and open the public hearing. So Nick, on to you.
Thank you, Chairman Lear and fellow commissioners, staff members, and the public that is listening. I'm going to share my screen and then get started with a slideshow presentation. So we are here tonight for an appeal of the Braidwood Hills 3rd edition. This was a tentative planned unit development and tentative subdivision that was considered back in July and into August last year. I was going to say earlier this year, but we're now in 2025. Just to give everyone a brief overview, this is an outline of the site, and I'm going to put my little pointer on. This is an outline of the site that was under consideration at the development site, and this is Hawkins Lane that comes down through here. You'll hear references tonight to a street called Randy Lane. Part of that street is right here and developed. Another here. There is no portion of Randy Lane through this site. It's not there. There's also, it might be a mention in some of the materials of Blacktail. I can't remember if it's Lane or Drive, but that's right here. And it talks about the intersection right here of Randy Lane and Blacktail, and some of the information that's in the record. This is a snap or a snip of their submitted site plan that was under consideration. And you can see, again, here is Hawkins Lane. This is Randy Lane. This is the stub of Randy Lane at the southeast. And you can see the configuration of lots here with some private streets. There is a Goal 5 creek or stream bed that runs across the property right here and is identified. There's also wetlands that are shown. And then the lot configuration. You'll also hear discussion in this appeal about the extension of Randy Lane. That is this portion right through here that is shown on their site plan. So we'll turn around right here. So just for the brief background, tentative PUD and tentative subdivision applications for a 39-lot residential subdivision. As I said, we did this back in July with a decision in August, or actually a decision in September by the hearings official who denied the application. This was appealed by the applicant with 10 appeal issues, and tonight we'll go through these appeal issues. The applicant will present some testimony, some information, the public will speak, and then we will hold deliberations on January 21st and 28th. So I'm going to talk about the 10 issues. I'm just going to give a brief overview. Because these things are complicated, we wrote a very in-depth AIS, or agenda item summary, as we refer to, that goes into great detail in here, and I don't have the time to go into the details that are in that, but I just wanted to give a brief overview so we all understand what the appeal issue is, what the hearings official determined or found, and what we're recommending that the Planning Commission do on these issues. So the first appeal issue number one, is basically that the applicant argues that the hearings official erred by rejecting rebuttal evidence submitted by the applicant during the second open record period, which was on August 14th of 2024. And the hearings official rejected this information on procedural grounds, deciding that it was new evidence and not responsive to evidence in the first open record period. What we're asking or recommending the Planning Commission do is consider that all of this evidence submitted by the applicant in the second open record period was responsive to evidence and testimony that was submitted during the first open record period, as is required, and that you make that finding and reverse the hearings official decision. Appeal issue 2 is that the applicant argues that because the subject property is listed on the scenic site's working paper, figure H2, it is a Goal 5 resource. Therefore, the tree preservation standards referenced in Eugene Code 9.8325 do not apply, and the hearings official erred by denying the applicant's application. This is a pretty in-depth appeal issue. There's a lot of information in our AIS about this. Basically, the hearings official did not find enough evidence in the record to be able to determine that the entire site is on the Goal 5 inventory, specifically about the scenic sites working paper from 1978 and the figure H2 map that was included that identifies this site as having plentiful vegetation and a site that we have always looked at when they get those designations as having a goal, as being on our Goal 5 inventory. What we're asking, and because of that, there is an exclusion in the Eugene Code that says that if it, or basically it says if it's a Goal 5 site, and then the tree preservation and removal standards do not apply. We're asking that you consider reversing the hearings official decision on this and find that the figure H2 map that was included in the record is a document that forms the city's acknowledged Goal 5 inventory, and therefore the entire site is on the Goal 5 inventory, and therefore it's exempt from the tree preservation and removal standards. What I'm talking about is this map that is used when we look for sites that are Goal 5, and you see the blue areas here, the little blue clouded areas. Site is depicted, I think it's either right here or I think it's right here somewhere, and I'll show you in the next slide how we determine that. What we do is we look at where it is. As you can see in this blow up from the H2 map, there's no property boundary, so it makes it a little challenging. So what we do is we look at an aerial from our other mapping data that we have, and we look for things that are the same. This is Oak Patch Lane, this is City View Lane, or City View. This is 28th right here, and we find them here on these maps and locate here where the star is. So that's how we figure out where a site is in relation to this map. And it's called prominent and plentiful vegetation on the legend on the map. The third appeal issue is that the applicant argues that the hearings official erred when making a finding of compliance with the secondary emergency access standard on a condition prohibiting any parking on the streets with 21 foot of paving. And what happened was that the hearings official found compliance with the standards in our Eugene code about secondary emergency access, but she added a condition prohibiting parking on both sides of the street based on comments that came in on the day of the hearing from the Eugene Springfield Fire Department, which talked about wanting no parking on both sides of the street. What we go into detail in our agenda item summary is that the fire department standards are not part of the Eugene code. Our code, when it comes to compliance with secondary emergency access, point to widths of streets and the amount of right-of-way and the amount of paving. What happens is at building permit stage, when the streets are being built, when properties start getting built, the fire department weighs in and they can institute their own standards at that time and require no parking signs. And then the applicant or whoever's constructing would have to do that. That is the appropriate time for the no parking signs to go in. And then the fire department does the enforcement on the no parking issue. So we're asking you to modify the decision on this issue. You find that the site does comply with the secondary emergency standards, but that the parking prohibition on the streets is not needed to meet our code requirements. Issue number, and I'm hoping that no one's trying to ask me any questions at this stage. There's a little lag on the device I use to hear, and sometimes it takes 4 or 5 seconds. So if someone's trying to get my attention on something, I might have to say a few things. I apologize for that. I should have thought of that in the beginning to let everybody know. Issue number 4 is the applicant argues that the hearings official erred by not considering the applicant's evidence submitted on August 14th during the second open record period, which rebutted Public Works' first open record evidence that was submitted on July 31st, that the applicant had not justified an exception that is allowed in the Eugene Code to connect to Randy Lane. And so this relates to issue 1 when the applicant submitted evidence in that second open record period and the hearings official rejected it as new evidence. We are asking that you find that the evidence submitted was responsive to the new requirement that was introduced in the first open record period by staff to make the extension of Randy Lane a public street instead of a private street, and demonstrate that the exception under the street connectivity standards to connect it all the way to Randy Lane at the southeast portion of the site could not be met due to the steep slopes that are incurred and would not meet our code requirements. What I am talking about here is this section. This is a blow up of the site plan. This is the end of Randy Lane as it was proposed when it was a private street. This is the stub of Randy Lane at the southeast corner of the site that exists today. And what the applicant demonstrated with that evidence they submitted in the second open record period is that, as you can see here with the topography, these slopes are too steep to meet the city's standards for streets and that exceed 20% slope. So the road cannot be built to street standards through this area. And so we're asking you to, as I said, to reverse or modify the decision and accept that information that was submitted that demonstrates the exception is they qualify for the exception. Issues 5 and 6 were so closely related, we grouped these together. Basically, this is that the applicant argues that the hearings official erred in concluding that the applicant failed to show there is no need for the extension of Randy Lane to be developed to public road standards. The hearings official also erroneously rejected the applicant's argument that the demand for a public road stub is not justified under constitutional law. And as I mentioned, the original extension of Randy Lane was proposed as a private street. As we got into this process, we realized there was a direct and need to make this portion of Randy Lane also public. And what we're recommending is that you uphold and modify the decision and find that Randy Lane should be a public street with conditions of approval that we've proposed, and that in the public interest to require that Randy Lane be public. Issue number 7 is that the applicant argues that the hearings official erred in requiring compliance with the requirement for a geotechnical certification that's in our code at Eugene Code 9.6710 sub 6, due to the applicant's failure to carry its burden of proof that the site is on the acknowledged Goal 5 inventory. And this relates back to the issue number 2 about the status of the whole entire site as Goal 5. And again, the hearings official did not find there was evidence to determine the site was on the Goal 5 inventory. Again, this relates to that H2 map that I showed earlier. Therefore, the need to demonstrate compliance with the requirements of code would be that they would have to do a geological and geotechnical analysis of the site. We are asking the Planning Commission to modify the decision and find that the figure H2 is a document that forms the city's acknowledged Goal 5 inventory, and that the entire site is Goal 5. It is exempt from the requirements for the geological and geotechnical analysis of the site. The thing I want to add here is that as individual properties get built with homes, they will have to demonstrate the feasibility under geotechnical standards to be able to build homes on the sites with these slopes and with the conditions. So there will be a look at the geological condition of the land when anything is built. Just wanted to make that clear for the commission. And again, this is that proposed portion of Randy Lane that we have determined needs to be a public road rather than a private road, as an extension of the existing public road right here. Issue number 8 is the applicant argues that the hearings official erred by not finding that the proposed stormwater system can comply with the city standards for stormwater, even if the system must be adjusted in the event that Randy Lane must be a public road. And so what happens here is when we made the requirement for Randy Lane to be public, there are different stormwater standards that come into play, and they have to do additional things to detain water in the right of way. And so it was going to require changes to the stormwater system that they had proposed. And so because this came during the process, we wanted them to be able to submit the stormwater updates at the later stage prior to final plat, knowing that we were pretty confident, or at least Public Works was confident, that they would be able to demonstrate an ability to meet the stormwater standards, but they just have to design a bigger system and then dedicate it to the public, or to the city, basically, as a public storm system rather than a private system. So we're asking you to modify the decision and find that the requirements in our code can be met with a condition for redesigning the stormwater system required for the public portion of Randy Lane prior to final plat. Issue number 9 is the applicant argues that the hearings official erred by finding that because almost all of proposed lot 39 is above 901 feet, and the land comprising the proposed lot 39 did not exist as a separate lot on August 1st, 2001, the applicant is prohibited from further development on that lot. The hearings official found that our code is clear, that no development is allowed on a lot that's above 901 feet, as is almost all of lot 39 is above 901 feet. And it did not exist as a separate lot in that configuration prior to or on August 1st, 2001. We're asking you to uphold and modify the hearing's official decision with a condition that there's no development above 901 feet. The condition. Last appeal issue. Appeal issue 10 is that the applicant argues that the hearings official erred by not doing a separate review of the subdivision proposal, relying instead on the analysis of the tentative PUD approval criteria. And basically what happens here is that the tentative PUD approval criteria, which is extensive, is almost all of the subdivision approval criteria is the identical criteria that is in the PUD criteria. And so what we did in our staff report was whenever the criteria was exactly the same, we referenced the findings that we had made in the PUD criteria and saying, therefore, since the subdivision criteria is identical, it meets the criteria. There's a few places in that part of the decision where the criteria is a little bit different, and that was explained in our staff report, and then the hearings official adopted that part as part of the findings for the subdivision, saying that it was substantially similar. What we're asking you to do is, this one's a little tricky in that we're asking you to uphold the hearings official decision and find that the reliance on the PUD criteria for any of the criteria in the subdivision that is identical is valid. But we're asking you to modify the decision because we're asking you to find that the PUD criteria is met. Therefore, the subdivision criteria is now met if you decide to go with our recommendations. The other thing I want to just mention is that the end of our agenda item summary, there was a number of attachments. The very last attachment is a list of, I think it was 28 or 29 conditions of approval. And those conditions evolved from the original conditions that we included in our staff report that was done in the beginning of July, that the hearings official relied on to review the applications. And then in the first and in the second open record periods, we recommended some additional conditions and also modifying some of those existing conditions. And so because the hearings official never or didn't give an approval of this application, there were no conditions put into her findings. And so basically we have to now insert all those conditions along with the ones we modified during the process for you to consider if you do end up approving this application. And with that, I will end my presentation and turn it back. Thank you.
Thank you so much, Nick. Before we open the public hearing, I have a few more details to share regarding our order of operations. We'll begin the public hearing with testimony from the applicant, who is also the appellant in this case. And testimony will then be received in the order that people have requested to speak. City staff will then have the opportunity to respond to the testimony provided and answer any questions that might come up. Finally, the appellant will be given the opportunity for a final rebuttal. I know commissioners have asked for more clarity on when it's appropriate to ask questions, and staff has suggested that if you have questions about someone's testimony, you should ask those questions following that individual's testimony. Following the conclusion of public testimony, staff will have a chance to respond to the public testimony presented, and commissioners will have the opportunity to ask additional questions of staff. I'll now hand it off to Lauren Summers to review the restrictions on the Planning Commission in this type of appeal.
Thank you, Chair Lear. My name is Lauren Summers. I'm an assistant city attorney for the city of Eugene. And because Planning Commission hasn't had a quasi-judicial appeal in a while, we thought it would be helpful for commissioners and also for folks testifying and people watching at home to get a little bit of context about the requirements and restrictions on Planning Commission in the case of a quasi-judicial appeal. So it's an on-the-record appeal, which means that the Planning Commission cannot consider new evidence that was not available to the hearings official. The Planning Commission is limited to looking at the information and evidence that was available to the hearings official. And the Planning Commission is also limited by the appeal issues that were raised by the appellant. So the Planning Commission could not itself decide to take a look at a part of the hearings official's decision that the appellant is not challenging. So the two limitations are no new evidence and only the appeal issues raised by the appellant. And what Planning Commission is really doing in the course of this appeal is asking yourselves, did the hearings official get it right? Based on the information that she had, based on the applicable criteria, did she get the decision right when it comes to those issues that have been identified by the appellant? So for folks who are testifying, and I know Commissioner Lear will say this again, what is most helpful to the Planning Commission is to kind of structure your testimony in a way that does not include any new evidence, any new information that the hearings official did not have, and also that really hones in on the appeal issues that were identified by the appellant that Nick just walked through, because those are the things that Planning Commission will be considering. And I think that's it for me. Thank you for letting me take the time, Commissioner Lear.
Thank you so much. I would also remind everyone that failure to raise an issue with sufficient specificity to allow the Planning Commission and parties to respond will preclude future appeals on that issue. In other words, please raise issues as clearly as you can so the city and other parties can address them. And before we open the public hearing, I think Crystal has some further instructions for us on providing testimony.
Thank you, Chair Lear. So hi again, everyone. It's now time to sign up if you would like to speak tonight and provide testimony. You can get into the queue by raising your virtual hand. To do this, please click on the raise hand button in the menu if you're joining us on a computer or a smart device. If you're joining us by a phone, you must dial *9 and you'll receive audio confirmation that your hand was raised. You can start raising your hands now as I continue to provide instructions. Traditionally for these proceedings, once the public hearing is open, speakers were called in the following order. First, the applicant, who is also the appellant, and then 2, all others who wish to speak. The applicant will also be given a final opportunity to respond after all the testimony has been provided. At the start of your testimony, please start by clearly stating your name, your address, and if you are in favor, opposed, or neutral to the proposal. I will announce whose turn it is to provide public testimony, as well as announcing who is up next. When you are called to provide testimony, you'll be promoted to a Zoom panelist, which will allow you to unmute and turn on your video if you would like. Please do not unmute or turn on your video until it's your turn for public testimony. When your public testimony is concluded, you will be returned to the Zoom attendee status. Public testimony is limited to 3 minutes, and when your public testimony is concluded, you will be muted. So please be mindful of your time. If there are any technical difficulties during your testimony, we will move on to the next person in the queue and try again after that person's comment. After all that, I will hand it back to the chair.
Thank you, Crystal. Now I'd like to open the public hearing. The purpose of the hearing tonight is to receive relevant testimony on the appeal before us regarding Braywood Hills 3rd Edition. I want to remind everyone that your testimony must be directed toward the issues identified in the applicant's written appeal statement and the applicable approval criteria from the Eugene Code relevant to each appeal issue. No new evidence can be accepted by the Planning Commission, and we can only accept testimony related to the evidence that is already on the record. What this means is that you should be testifying about 1, the materials and information already presented to the hearings official in the first public hearing process, and 2, whether or not you think the hearings official made a mistake based on the applicable approval criteria. Crystal, how many speakers do we have currently in queue?
We have 12 speakers in the queue.
All right. Thank you. We will now begin public testimony, beginning with the applicant. And Crystal, I'll hand it off to you to begin.
Excellent, thank you. So again, I want to remind everyone to raise your virtual hand if you would like to speak tonight. Also, at the start of your testimony, please begin by clearly stating your name, your address, and whether you are testifying in favor of the application, if you are neutral, or are testifying in opposition. I will also notify you when you have 30 seconds remaining in your time. So with that said, we are going to begin with testimony from the applicant's agent, Bill Cluse, an attorney, and then we will be followed by Charles Woodward. And I'm working to promote you as Zoom panelists now, so bear with me. All right. All right, so with that, Bill Cluse, you are up first, and we will let you begin. Your time starts now.
Oh, thank you very much. I feel impaneled and you can see me and hear me, right? Great. Am I limited to 3 minutes? It's about 20 seconds an issue.
So this first part, it is 3 minutes, and then you are given an opportunity to have a rebuttal period after all testimony.
And how long will my rebuttal period be?
Oh, that's actually a great question.
It's not limited. I'll just add.
Thank you, Gabe.
Okay, so I have 3 minutes for opening and then I have unlimited rebuttal.
Correct.
Can I switch it around the other way? I mean, it's not, doesn't make comment. It does not logical, functional, or it has no, it's just backwards. It would have my comments, my homily would have the most utility for the Planning Commission if I had more time at the front end and less time at the back end. I've never been in a situation where I'm appealing at the Planning Commission on a site-specific item and I'm limited to 3 minutes in the opening remarks.
So typically, Bill, I'm going to jump in. Typically, the applicant does get more than 3 minutes. Typically, the applicant will have worked with staff ahead of the public hearing to identify how much time you need. So
I did.
That didn't happen here. So
it did.
What are you requesting?
Honestly, I did open this issue with staff and asked, and I really did not get an answer. I can get by with 15 minutes.
Okay. Crystal, can you put 15 minutes on the clock, please?
Will do.
Thank you. And just to be clear, for those who are listening, this is typical. The applicant does get more time because it is their appeal. That is what our code provides for. Everyone else will be limited to 3 minutes. So I just wanted everyone to know that. Okay, thanks, Bill. You may go.
Start the clock. Thank you very much. Commissioner Bill Close for the applicant, 375 West 4th Street, Suite 204 in Eugene. This has been a long, serious dust up. You have a huge record in front of you. I have done my best to organize things to make this efficient. You all should have a 12-page handout for me, of which the first 7 or so pages relate to the substantive issues, and then the last few pages relate to my comments on the staff's proposed conditions, and really that's for later. So we're really talking about the first 6 or 7 pages. On my first page of my handout, which came to you by email courtesy of Nick, I have made my own table of contents of the significant documents from the 159-page staff report. That is, it's a big fat staff report, had to be by necessity. I've listed the items that are most critical to my presentation and given you a PDF page number, all for handy reference. So I'm just thrilled that we have staff support on really 7 of the 10 issues. And because issues 5 and 6 relate to the public versus private status of Randy Lane, we're really down to 2 issues. Issue 9 is whether the city may use its overlay zones, its PD overlay zones, to limit or negate our middle housing statutory middle housing rights. And then issues 5 and 6 relate to Randy Lane status. Let me jump to the Randy Lane public-private status and get that out of the way. And my remarks in my handout start at page 6. It's really a question of whether or not Randy Lane can be private, like the other 2 streets, or whether it must be public. We were flabbergasted at how the city shifted gears on this, because up through the application, up through the review by staff, up through the hearing, the city was on board that Randy Lane could be private for the same reason that the other 2 roads can be private. That is, they can't connect to anything. This one can't connect to anything because the topography gets too steep. And so we got all the way through the hearing with city staff saying, public works staff saying, fine, they can all be private. And then 3 weeks after the public hearing, public works shifted gears on us, shook up everybody, I think, including hearings official, and said, no, it's got to be public. And that's where we're at now. Our basic pitch that there's no need for this street to be public is that it cannot be extended due to the topography. It can't be connected to the east end of Randy Lane. And I see a secondary argument in public works staff's comments that, well, there's a lot of lots that are served by Randy Lane, and that's going to generate high ADT, and it really needs to be public. My crib notes there, which I've given you, show that there are 7 lots that are served by Randy Lane Extension. 37 and 38 are being combined into 37. So there's 7 lots. The other 2 roads, private streets, have 9 lots served and 21 lots served respectively. So the number of lots served rationale from Public Works does not hold up either. So we just haven't seen a solid logical basis for requiring that road to be public. So we are still talking to staff about that. Maybe something can be worked out, but that's it for tonight. So with that, I want to shift back to the big issue of the evening, which is the city's position on the lot 39, which consists of the 2 acres that are above the 901-foot elevation. This issue involves a train wreck between the city's interest in enforcing the standards in its code, the PUD standards. If you want clear and objective standards and you've got a PD overlay, you are subject to the 901-foot no development limitation. We went with clear and objective because that's the way you're actually getting an approval. The city is of the position that it is allowed to apply its code on this issue. The applicant is of the opinion that the statute controls. It supersedes the city's code. That's the way it is. Statutes always apply directly, notwithstanding the code. The question then becomes, what does the statute mean? And when it comes to determining what a statute means, there are rules set for construing the statute that are laid out by the Supreme Court in the PGE line of cases. We provided that PG analysis in our August 14th submittal to the hearings official. And that appears in, there it is, pages 95 to 106 in the staff's staff report. That is a full PDF analysis done the way the Supreme Court says it has to be done. And based on that analysis, the statute controls and allows us, creates middle housing rights for this property. And so our position is that the city may not use its code to defeat those middle housing rights. The middle housing, and on page 2 of my handout, I quoted the operative language from the statute. It's right there. It says, except as provided in subsection 4, each city with a population of 25,000 or greater shall allow all middle housing types in areas zoned for residential use that allow for the development of detached single-family dwellings. And so when we look at that, the phrase that we're all focused on here is in areas zoned for residential use. When we look at that phrase in the context of the entirety of the middle housing statute, we believe that that phrase means areas with base zoning that allow single family detached. And of course, Lot 39 has R1 zoning like the entirety of the rest of the site. It's all R1 zoning. And so we start with the premise that the statute guarantees that that Lot 39 has middle housing rights. 1, 2, 3, or 4 units can be developed. Single, duplex, triplex, or quad. And then the city said, no, 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 we get to apply our 901-foot development prohibition, notwithstanding that statute language. I believe that the city is of the opinion that the reference to areas zoned for residential use means areas zoned for residential use when you consider all the zoning, the base zoning, and any overlays that the city wants to put on it. Our view is that's the wrong interpretation of the statute. For a year, we have been after the city to do its own PEG analysis of the meaning of that statute, and we have never seen it. It hasn't been done by the director, hasn't been done by in the staff report, it hasn't been done by the city attorney, it hasn't been done by the hearings official. It needs to be done. In our view, we would appreciate that we tried to get the city to take a timeout in the proceeding before the hearing official so they could do that analysis, and it never happened. Our letter to the hearings official, we saw this issue coming in the fall of, our letter to the hearings official, July 10th, explains we saw this issue coming in the fall of 2023 when we were meeting with the staff about this project. And I thought, uh-oh, this is going to be a train wreck. We need to get this figured out. You know, what is the correct interpretation of the statute, and does it override or is it subject to the city code? And we need to get it figured out before this winds up in a big pile at the Planning Commission. And so I had the Home Builders Association file with the city a zone verification letter, which raised this issue with the understanding that if the city stuck to its position that the 901-foot limitation controls over the statute, then we could take that issue to LUBA, as we've done before with director interpretations that we don't like. And we would have an answer from LUBA on how to correctly read the statute. And that could be folded into this proceeding in front of the hearings official. And this issue that we have right now would never get to the Planning Commission. I thought that was a brilliant strategy. And so that application for zone verification by the home builders was filed on December 28th, 2023. What was the answer? We don't have an answer. The answer is there ain't no answer, because the planning director has never issued the decision in response to our zone verification application. It's just sitting out there in space somewhere. Very frustrating. So we've done everything we can possibly do to get the city to take a little time out and do a competent analysis, PG analysis of this statute and its relationship to this code language. We have not been able to get it. Is this a new experience for the city? No. My outline remarks there provide a little more detail on issues we raised on the past experience we've had with the city on this issue, and particularly in the context of the Camps Hughes trilogy of decisions in 2018, 2019, and 2020. The Camps Hughes LUBA decisions related to the ADU statute, which was the little sister and predecessor of the middle housing statute. It was a trial run. And we got 3 zone verification letters from the director saying that Mr. Camps Hughes could not put another dwelling unit on his alley access only lot in the Fairmount neighborhood. And Each one of those, Lewis sent the city packing because they were not interpreting the statute correctly. They were giving precedence to the city code over the state law. And I'm suggesting to you, there's more details there, you can read my notes on that, but I'm suggesting to you that the city is committing the same sin here. They're not doing the proper analysis on the statute, and as a result, they're trying to apply the code language when they can't do that because it conflicts with the statute. So that's the big picture.
Just under 3 minutes remaining.
Oh, that's great. I'm glad I asked for 15 minutes. I think that ultimately on this is the big issue in this case. And I think the commission has really 3 options in dealing with it. One, they can say, well, Mr. Close is right that when you are trying to understand the relationship between a statute, like the middle housing statute or the ADU statute, and local code provisions, you have to construe the statute using the rules that the Supreme Court says you must apply. That's the PGE line of cases. Look at the text, look at the context, look at the legislative history. And when we look at the record, nobody else has done that analysis. Not the director in this application, not the director in the context of the zone verification she's been sitting on for a year and a couple months. Not the staff in the staff report, not the hearings official, not the city attorney. So we're going to go with the applicant. They're the only ones that have done a correct analysis of the statute. And so we're going to go with that. And we're going to resolve that issue in favor of the applicant. That's one approach you can take. The other approach you can take is, you know, Mr. Close may not be right about interpreting the statute, but he is the only person that's done a full analysis of it. And so we're going to turn to the planning director and say, planning director, city attorney works for you. Would you please ask the city attorney's office to do a full PGE analysis on this issue? You know, what does that statute mean in relation to the 901 development prohibition? The third option for you is to just get on board with planning director. Planning director is asking you to just apply the code. Don't pay attention to the statute. And you could do that too. I think that's really the big picture. I'm happy to entertain questions. I guess this is the time.
30 seconds.
I'm done with my presentation. If there's any questions the commission has, I understand that now's the time for them to ask me.
Thank you. Do we have any questions of Mr. Clues? I've got one actually. So you're interpreting ORS 197A 4202 sub A as stating that because the base zone is R1, that permits or requires that that middle housing is permitted there. But I'm curious about your response to the fact that it's not specifying base zones, but areas zoned for residential use that allow for the development of detached single-family dwellings. Because to me, that might suggest that it is an area which has the correct zoning and which allows for the development of detached single-family dwellings. So I'm just curious about your interpretation. I think you're on mute, Bill.
Sorry, one question, just procedurally, I'm sorry. Are we allowing questions and a response at this time? Or would this be something more appropriate to answer in the rebuttal at the end?
Defer to
I think
Lauren, maybe.
I think it's fine to allow it at this time.
Okay, thank you.
I'll just ask Bill to unmute.
Bill, you're on mute there.
I'm not sure how that happened, but people are always trying to shut me up, so I guess it happened again. That is the key question here. the language in the statute says areas zoned for residential use. So it's not explicit that it's base zone. And that's why you have to construe the entirety of the statute. You look at the text of the entire statute, middle housing statute. You look at the context, the language in which that statute is embedded. For example, the ADU statute from 2017 is context for the middle housing statute. It's all packaged together. So you look at the text, which is right here. You look at the context, and you look at the legislative history, which is very important in a situation like this. All those three things you look at are all relevant to determining the intent of the legislature. And the Supreme Court in PGE says the intent of this construction process is to determine the intent of the legislature. You do that by looking at text, context, legislative history. In pages 95 to 106 of the staff's PDF, we have done that. And I will say that's the most exciting pages. That's the most exciting 11 pages of the staff report right there is our PGE analysis of how the middle housing statute relates to the city code. Put your feet up, read those 11 pages, and then you ask yourself, well, where's the city's PG analysis? It's missing in action. And so it would be really functional for the commission to have the city's view of the correct PG analysis to match or to contrast with the applicant's PG analysis of construing the statute. But to be more specific in answering your question, the structure of the statute is it states this flat rule here. If your zoning allows single-family detached, you get middle housing rights, and then it has some exceptions stated. And for example, one of the exceptions is for overlay zones that implement and protect the protective goals. So for example, city regulations protecting the greenway are exempted out from this general rule. City regulations that protect Goal 5 resources, they're exempted out from this general rule. So the structure of the statute is, this is the general rule, and here's some exceptions. The exceptions don't list all other overlay zones. There's no language in the balance of the statute that says, oh, by the way, the city can apply its overlay zones. The language is, the city may apply its overlay zones that protect Goal 5 resources and protect Goal 15 resources, and so on. So there's no exception that allows the city to be doing what it's doing here. Again, going back to my main point, look at the text, you look at the context, and you look at the legislative history. And we've done that, and the city has not. Please ask them to do it. There's no rush here. We've been at this for a long time, and we've got to get it right.
Okay, thank you.
I'd rather win this at the Planning Commission than taking the decision to LUBA and trying there. As you can see, the Camp Hughes matter in the context of the ADU statute went to LUBA 3 times in the Court of Appeals once. And every time the city got a serious dressing down. I'd like to say those are exciting reads, but they're all kind of tedious.
Okay, it looks like we've got another question, Commissioner Edwards.
Hey, thank you, Commissioner Lear. Bill, my question, so I'm trying to just kind of understand what you're saying, and it sounds to me like what you're saying, and I want you to correct me if I'm wrong, is that there is language in the statute that says that overlay zones that cities have would override the middle housing provisions that are in the base code. But because this development over 901 feet does not exist in an overlay zone, and in fact, it exists in the provisions of the South Hills study. Is that what you're saying? And that's not technically an overlay zone, or?
Very, very close. Very close. If we didn't have an overlay zone on this, all of the South Hills are blessed with an overlay zone.
Okay.
PD, such a blessing, right? Such a blessing, especially if you want to build housing. If if this property only had the R1 zone on it, we wouldn't be talking about the 901 prohibition because it's not in the base zone. It's only in the PD overlay zone. And not only that, it only comes with the overlay zone for people who want to go clear an objective track. You know, if you want to choose the discretionary track, there's no 901 prohibition. So staff will say to us, as they say repeatedly, Bill, you don't like the 901 prohibition? Go apply under the general track. And I say, yes, my friends. But if my client applies under the general track, there's so many discretionary standards, you can say no to the whole project. Well, that's true, Bill. Trust us. Well, I've had too many projects in the South Hills over 40 years where I applied under a general track, and the answer is no. And then they say, try again. So to get a more specific answer to your question, this prohibition, the 901 feet prohibition, comes only with the PD zone and only in the clear and objective standards track. And to go back to the earlier question, there are exceptions or carve-outs in the statute to apply overlay zones that conflict with this general rule in the statute. And the statute basically says, hey, you got regulations that protect Goal 5 resources, apply them. You got regulations that protect the Willamette Greenway, apply them. It's okay. But we don't have, the only Goal 5 resources we have here are the setbacks on either side of the Goal 5 stream. Those are being honored. So that's it.
Okay, thank you. That was
You
helpful.
bet.
Don't see any other hands up. Crystal, if you want to call whoever's next.
Excellent. So Bill, we're going to return you to the attendee list and we will re-promote you back for the rebuttal period.
Thank you.
And then Charles Woodward, you are up next. And Randy Groves, you are on deck. I'm going to be promoting you to panelist here in a moment. Charles, before you begin your testimony, just give me one moment to get prepared. Thank you for your patience. So sorry. Okay.
No worries.
All right.
Can you guys hear me okay?
We can, yes. And your time begins now. 3 minutes.
Charles W. Woodward IV, 44 West 35th Avenue here in Eugene. I'm an attorney hired in this matter. Going to the first, the prohibition on construction over 901 feet. Fortunately, as whether the city's comments on this particular matter rise to what Mr. Kloos would consider a full PG&E analysis, regardless of whether he believes that happens, I did actually do a pretty good PG analysis in my statements that were from August 14th. I turn you to page 2 and 3 where I address the actual specific language. Again, as Commissioner Lear has pointed out, the area and the zone rather than the base zone, and of course imputing the word base zone would violate ORS 174.010. So the applicant's continued insistence on relying on the base zone would violate statute as to adding things into the actual law that are not there. And again, I will refer to that particular statement that goes quite in depth into some of the context and the specific language of both the statute and the city code for greater clarity on that matter. And contrary to Mr. Kloos's assertion that that's the main gist of this particular appeal, I would reckon to go quite a different way, and I would say the whole issue is the Goal 5 and the actual designation of the entire subject property as protected Goal 5. Despite previous assertions to the contrary, the applicant originally was under the impression that the entire site was not Goal 5 under the scenic view. And please separate the fact that the Goal 5 stream remains Goal 5. So when I'm talking about Goal 5 resource in this instance, speaking of the entire site being designated as a scenic site. Basically, we come down to Ordinance 20351. And in 20351, you'll find a recital, which is what the entire argument hangs their hat on. and you will look at the recital, and it is an inventory list which qualifies under the applicable governing statutes for acknowledging Goal 5 resources, which is OAR 660-023-0030, which would be the inventory process whereby significant sites are identified. Not acknowledged sites, significant sites. To be
30 seconds.
To be an acknowledged site, doggone it. Read my hearing statement that I gave you guys. It goes into it. Basically, the ordinance does not do what they expect it to. There was no ESEE analysis, which is section 040. There's no Goal 5 regulations that are done pursuant to the ESEE analysis, which is 0050. Goodness gracious. And Randy Lane should be public. I think that's, I don't have enough time. I don't get my 15 like Bill did.
And that is time. Okay. And Randy, before you begin, just give me one moment to get situated here. Okay. And Martha, you are on deck after Randy. I'm going to promote you to panelist now. Okay, Randy, if you're ready, you can begin. Your time starts now.
Thank you. Good evening, commissioners and city staff. My name is Randy Groves. I live at 3208 Blacktail Drive. I am the city councilor for Ward 8, which includes this area. And because I'm a city councilor and we don't have a role in this process, I'm going to take a neutral stance tonight, but I do want to speak to issue 3. I've spoken with a number of constituents. I have attended meetings on this. I brought one constituent to meet with Nick and Gabe a while back to talk about this issue. But I want to speak to issue 3 from my former life as a 37-year professional firefighter and the chief of Eugene Springfield Fire. I recognize that a lot of fires concerns will come up at the permit time, but as fire chief, I frequently heard applicants complain, why didn't the fire department raise their issues earlier? So I'm raising the issues. I want to speak in support of the fire marshal. I have real concern with the 21-foot width of a street with parking on one side. Fire apparatus are generally between 10 and 11 feet, mirror tip to mirror tip. And it's more than just getting past a vehicle. If you're responding even to a medical call, when you stop and set the brakes, you've got to be able to open the cab door and the jump seat and have enough room to actually exit the vehicle. You also have compartments that carry a lot of equipment, whether they're paramedic EMS gear or fire suppression, firefighting gear. We have large ladders we have to move around. We have attack lines that deploy from the sides of the engine. And we have supply lines that are brought in by a second arriving engine that are hooked up to the side port on an engine. We need space. I personally would prefer to see the street widened because anyone who lives in Braywood 2 knows that people do not pay attention to the no parking signs. And this is a legitimate issue. You can say, well, it's buyer beware going into a neighborhood like this, but I'm also concerned about the houses up on Suncrest. That's a southwest exposure that is subject to solar heating in the summer, and fires love to run uphill. Look what's happening in Los Angeles right now. And one of my concerns is fire department's concerns are frequently minimized or dismissed
30 seconds.
Only to have a disaster happen later, and then all of a sudden that comes to light. I hope we can find a way to work through some of these issues. I think the neighbors do have some concerns that still need to be addressed. But again, I want to speak specifically to the issue 3 issue, and I want you to understand from my perspective what I'm seeing is a real problem. Thank you.
Thank you. Okay, Martha, before you begin, let me just get everything squared away. So one moment. Larry, you are going to be promoted to panelist now. You are on deck. And Martha, if you're ready, you may begin. Your time starts now.
Okay, my name is Martha Ciotti. I live at 2763 West 29th Avenue. And I would like to say that I agree with the hearing official's original decision to deny the applicant. If there are any future development proposals going forward in the future, I think they absolutely need to meet the tree preservation and removal codes that there are, especially because we've got oak trees and many other trees on that property. Some of the oak trees are over 300 years old. They are home to animals that are in this area. Also, I was struck in the beginning of this how the gentleman gave reverence to the people of the land that lived here before us, the stewards of the land, and mentioned that, you know, being stewards for future generations. I drive around Eugene. I don't see very many green areas. This green area is beautiful. When I go on walks, I meet people that are not from this neighborhood that come up here just to see this area. I implore you to allow us to preserve this as a natural habitat for the animals here, for the natural beauty, to just enjoy our planet before it completely gets paved over. So I guess I'm appealing to the heart here. Other people will appeal to the head and to the different statutes and stuff, but I'm appealing to the heart. So thank you so much for your time, and I will sign off before my 3 minutes.
Thank you, Martha. Okay. All right, Larry, you're up next, or you will begin speaking here soon. Carrie Green, I am going to offer you the panelist position here in a moment. Okay. And Larry, if you are ready, you may begin. Your time starts now.
First of all, can you hear me?
We can, yes, thank you.
Can you see me?
We cannot see you though.
How do I do that before?
Yeah, there should be an option to turn on your video.
Okay, there we go. Okay, I got it.
There we go. Yep, now we can see you.
Yeah, please don't start the clock until I get to where I can be seen here.
Yes.
Okay, all right, begin. My name is Larry Smith. I'm at 3325 Videra Drive. We're downstream from the development, directly affected by it. I'm representing the Videra Drive Homeowners Association. And this issue has been going on a long time. I'd encourage you, if you haven't been able to read the thousands of pages of the public record that's out there, I would encourage you to at least look at the document that I have tendered, which is a testimony. It's only a few pages, but I'd point out that there are no new facts or data presented in that. And in addition to that, I had prepared a 20-minute video that I'd hoped to give here because I didn't know if I'd be able to attend tonight. If someone asks me a question, I can do like Bill and I'll play that video for you in response. I'd love that because I don't think it's fair that they could spend that much time and we have just as much concern and as much information as the advocate has. And I would love to be able to respond in a format where you can really collectively look at it. So with that, let me indicate that you probably saw in the Register Guard last March that we had a landslide up here. The first we knew about it was when the police and firemen showed up at our doorway and that demanded that we evacuate. There were 8 houses that we had to evacuate. We gathered some stuff and left right away. Turned out it stabilized and we didn't get affected. But we have one of our residents up the road that was devastated. His house had to be stabilized. It took 10 months to fix the damage, hundreds of thousands of dollars. Now, that happened because of hydrological pressure, which has increased over the years, especially with the high rainfall. So please do not look at the storm water as just something to be marked off on the list, which, by the way, in marking off the list, you might notice that the Public Works Department and the planners did not even require that the applicant file on any information on or answer the questions on the application which have to do with stormwater. They looked at the Goal 5, which I call the provision for exemptions for Goal 5, which to me are kind of a poison pill that's in the code. I don't know how that got in there. It's absolutely contrary to logic.
30 seconds.
You would look, how much?
30. You have 30 seconds.
I have 30 seconds. Please deny this. let me show you some of the facts are incorrect. The information is incorrect. For example, here you can see they estimated the basin size by 140%, which directly affects the amount of water you have to account for. They also underestimated the amount of detention required by a factor of 80. They only.
I'm sorry, your time is up. Okay.
We got Nick's hand up over there.
Yeah, thank you. I just want to remind Larry that I've not received a video. He referenced a video, and he even talked to me about this a couple days ago. I've not received a video. If he wants to get that into the record, he needs to submit it to me before the close of the record period, which I believe might happen tonight. So Larry, if you're listening, shoot the email with the video, and I can put it in the record.
Thanks, Nick. Okay. Carrie Green, you are up next to speak. The Zoom attendee listed as Shields household. I'm going to promote you to panelist. You are up next. And Carrie, you are able to begin. Your time starts now.
Oh, okay, thank you. I'm trying to start my video. Shift Command V. Thank you. Can you give me my full 30 seconds, please?
Yes, your 3 minutes begins
now.
my
full 3 minutes. Carrie Green, 2225 McLean Boulevard. I am opposed. I'm going to read some of the statement I submitted earlier this evening. Goal 5 determination. The issue of whether the property is a Goal 5 category of state land use planning regulations remains an insurmountable issue until an adequate inventory map can be produced and evaluated. The city is relying on a technically out-of-date 1978 map of scenic areas. Technology exists to inventory and update the features of the property to determine precisely whether the property meets the Goal 5 criteria. I believe the city is derelict in its duties to properly evaluate this property under that criteria. Property contains wetlands, of which 3.1 acres are proposed for removal. This accrues to 70% of the surveyed wetlands. They are a critical feature of the property. They provide a fundamental and irreplaceable natural hydrologic function. There is no geotechnical report that evaluates impacts of altering this property or impacts downstream of it by destroying the naturally functioning hydrology. Wetlands are an ecosystem service that support water filtration, provide natural flood and fire control, support wildlife, and reduce erosion. Until this property is definitively surveyed and mapped using current standards, Goal 5 remains a punching bag of arguments that cannot be supported either in favor of or in opposition to because no definitive data exists to support either argument. The city believes the property is Goal 5, and because of an administrative oversight when the housing clear and objective standards were developed, the city believes that cannot require tree preservation or require the applicant to conduct a geotechnical review. I have more that is submitted in my statement, but I will close by saying that the city's land acknowledgement statement regarding the indigenous stewardship of the Kalapuya people concludes, quotes, "Therefore, the Planning Commission recognizes that what we do today will affect the many generations who will come after us," end quote. I invite the Planning Commission and the city to consider how scraping 15.5 acres of trees and habitat, paving it over, pumping its water somewhere else, and erecting 160 homes on a potential heritage site is in the spirit and ethic of the Kalapuya people's stewardship. Thank you for taking the time to seriously evaluate the long-term deleterious effects of allowing the Pickle development proposal to go forward. I urge the Commission to render in denial. Thank you.
Thank you, Carrie. Shields household, before you begin, just give me one moment. Julie, I'm going to be promoting you to panelist. You'll be up next after the Shields household. And Shields household, if you are ready, you may begin. I'll start the time when you begin speaking. And you are muted. You may have to unmute first.
Hello, can you hear me now?
Yes, we can. Thank you.
All right, thank you very much for allowing me to speak today. Some of you might recognize my name and address, 2310 Shields Avenue. Diana Louise, L-U-I-Z. I attended several public meetings. I spoke in behalf in the past with what I thought was an understood objective. Now, as I continue to hear more, we go from a R1 to 160 homes without what I consider a fair evaluation of water needed to support that many homes. How do we pump it there? And, oh, by the way, you remember that big freeze that we had? What are we going to do with all that hardscape water that could have been and should have been absorbed from that area on that green land and now is hardscape and has to go downhill to somebody else? I live downhill from a unknown year-round creek that does not have a name that runs through my property. And yeah, as a private citizen, I paid for a geotech report to figure out where this water's coming from and how to get it off my property. What is the folks that are on the downhill side of this development going to do when the wetland is filled in and we don't have a sponge? We don't have a way to get the water off besides running through somebody else's backyard. Firefighting, we know that's an issue. We don't have enough water in our own systems to let alone add 160 units, maybe 3 people per unit. I don't understand where this water's coming from. Our firefighters might not have enough. We might have, are we going to build another tank of water? Our infrastructure cannot handle 160 new units sucking water that isn't there. This project has morphed from R1 to now we're going to bypass the original expectations of the people who went to this meeting and had an understanding. Now we're going back to the drawing board and caving to what this developer wants to do. Oh, it's more profitable now instead of R1. Oh,
30 seconds.
It's more profitable now, of course, without even considering the aftermath, 5 years, 2 years, 10 years from now, for this developer to make a whole lot more money on 160 units versus what they would have done on individual R1 units. Please, please take a bigger holistic picture. It completely makes no sense. We ought to start this project start it from zero. Right, Nick? Nick?
Your time is up. Give me one moment while I get everybody situated. Julie, before you begin your testimony, Wes Van Winkle, you are being promoted to panelist. You are up next. And
Crystal,
Julie,
did want to take an opportunity just to remind everyone who's speaking to try to focus on whether or not the hearings official made a mistake based on the applicable approval criteria, which is what we're allowed to consider.
thank you, Chair Lear. Okay. Julie, you may begin. Your time will start when you start speaking.
Okay, apparently my video is not showing currently. I don't know if there's a lag since other people have had this same issue.
Correct. We do not see your video.
Well, you should be because it's there. Let's see.
There we go. Now we can see
Okay,
you.
cool. Okay. First of all, I really wish you would have somewhere in the agenda identified or let everybody know that we only had 3 minutes because many of us had created testimony that went well beyond that, and we kind of found ourselves scrambling. So that would have been a nice thing to have done ahead of time. My name is Julie Butler. I am at 3234 Jayhawk Court, a couple blocks from the property in question. I am very against the plan as it stands, and I very much support the hearing official's decision to deny the application. In my testimony, which I've submitted to Nick already, I have 3 areas that have been appealed that I am discussing. One is the whole Goal 5 thing. One is the stormwater issue, and the third is the secondary access / concern with the signage and everything on that Mr. Groves brought up. You have to wonder why somebody wants something to be labeled Goal 5, an entire property be labeled Goal 5. Well, it's because of the loopholes that Eugene inadvertently put into its code, because they are created exceptions for tree preservation and removal, and they created exceptions for geotechnical and geological testing requirements for anything on Goal 5. Why is that? Well, because Goal 5 things are supposed to have buffers, and anything inside that buffer does not get disturbed, i.e. no construction, i.e. you don't have to worry about tree preservation because nothing's getting disturbed. You don't have to worry about soil or issues with that because it's not getting disturbed. So why in the world would a developer not want to preserve 300-year-old ancient oak trees? Why would they not want anyone to know ahead of time at this point in the process that there might be some problems with the soil composition, or that the landslide might be a risk issue, or that there are aquifers and springs galore underneath this property, something we are all who have lived around here very much aware. That wetland is constantly wet. It feeds the spring, or it feeds the Videra Creek all season long, even during the middle of our very, very dry summer seasons. It holds a lot of water, which brings the whole stormwater issue up, and that is a whole nother thing.
30 seconds.
All right. The last thing is I 100% agree with Councilor Groves. Having one entrance and exit, having a very narrow roads, it's a safety hazard. We've all seen what's happened in California. We all saw what happened in Hawaii. People are going to be put at risk. Lives will be lost. And who will be labeled as being at fault? And who are we going to point the fingers at for lack of foresight on this? The city is putting itself up for a lawsuit, just plain and simple.
And your time is up. Okay. Wes, before you begin, I'm going to promote Al LePage. You will be up next after Wes. And Wes, you may begin. Your time will start when you begin to speak.
Okay, I'm not seeing my video either, but you can hear me?
We can hear you, correct.
Okay, all right. The name is Wes Van Winkle. I live at 3025 Hawkins Lane. I'm across the street from the proposed development. And I'm also here as president of Save Videra Oak Meadow. We're a neighborhood group that formed precisely to stop this development. We want to buy it from the developers so that we can turn around and give it to the city as a park. I wanted to talk briefly about some conditions that we requested at the hearing officer's level, and they obviously were denied as moot or since the application was denied. But as Nick Jello pointed out earlier, now the commission may reconsider those conditions. And so I want to make sure this is before the committee. Before I say anything else, though, I want to emphasize that it's critical that the Planning Commission carefully review the documents, that the written submissions from Charles Woodward and Larry Smith, as well as the written letter that I submitted to the hearing officer prior to the last hearing. The conditions that we're requesting are first, that the developer design and install a single site-wide stormwater detention and filtration system for the entire 15-acre property, so that removal of the wetlands, which is what they're proposing to do, does not result in the release of unfiltered water onto the adjacent properties that more than currently occurs. Secondly, we want that stormwater detention system to be constructed before the wetlands are filled, so that removal of the wetlands does not result in a violation of the city's runoff equilibrium requirement for any substantial period of time. The developer, I think, understands that when they remove the 5 acres of wetlands, or 3 acres of wetlands, a substantial portion of this 15-acre property, that's going to result in water flooding off the property and gushing onto the surrounding properties. Much of it's going to fill Videra Creek. And Larry Smith's written presentation deals with that. But the solution they propose is to subdivide the lots, remove the wetlands, subdivide the lots, sell them
30
off,
seconds.
and then have the buyers develop their own detention system. That's not adequate. It's not adequate because, as anyone who lives up here knows, lots can stand up for sale for 20 years and not be sold. So during that entire period of time, the water is going to be flooding off the hillside onto the surrounding areas, and there's not going to be any mitigation imposed. That can't be. You know, that's a violation of the Stormwater Management Code.
And your time is up. Al, before you begin, let me go ahead and promote the next person, which is Frederick Poole. You will be up next after Al. Al, you may begin, and your time will start when you begin speaking.
Albert LePage, 1944 Cleveland Street, Eugene, Oregon. Opposition. Commissioners and all present, with respect and gratitude, I address you all as my relations, for we are all connected not only through the great genetic tree of life, but also in how our lives ultimately touch all others. I am in love with this landscape, with a special place called Videra Oak Meadow. The three comments I intended to make here tonight, however, although relevant to Goal 5 and tree preservation standards, dealt with process, especially related to the wetland permit application with the Oregon Department of State Lands, next, nature, and finally, community. However, in accordance with the good commissioner, as he reminded everyone, to respect the process in terms of really focusing on the specific appeal issues at hand, I will just encourage the commission members to please read the testimony I submitted in writing today, which is now already in the record. And I will just close with reverence to each one of you here, to the inherent goodness within each one of you. Thank you.
Thank you, Al. Okay, Frederick, give me one moment before you begin. Deanna, you are getting promoted next to panelist. You will be speaking after Frederick. Frederick, you may begin, and your time will start when you begin speaking.
Okay, you can hear me?
We can, yes.
Okay, thank you. Frederick Poole, 3055 Harold Lane, Eugene, Oregon, and I agree with the hearing officer that this should be denied. There's been different interpretations of how Goal 5 should be applied to this property. I just wanted to read OAR 660-015-0005 for Goal 5. The purpose of Goal 5 is the local government shall adopt programs that will protect natural resources and conserve scenic, historic, and open space resources for present and future generations. These resources promote a healthy environment and natural landscape that contributes to Oregon livability. The correct interpretation of how Goal 5 should or should not be applied, I would urge the commissioners to look at that statement and choose, or look at the interpretations and decide which one is most consistent with the intent of Goal 5. I think that will be the correct interpretation and guiding principle for how we should proceed with this property. The people here are not opposed to development; they're opposed to irresponsible development. And you've heard numerous reasons having to do with fire safety and stormwater runoff that have to do with the irresponsible nature of this particular development. The other thing has to do with, and again, so if we do or do not, if we look at the Goal 5 statement and how it was written and what the correct interpretation is, then we come back to tree preservation and removal standards and also geological and geotech analysis. And I'd also like to point out that because of the way this is being applied by the applicant, a lot of the cost is being transferred to taxpayers and to those potential homeowners who buy this and having to do their own geotech analysis, having to look at how they're going to protect their property against fire and egress and entrance and egress by emergency personnel. This isn't just the cost, the potential cost to residents and potential homeowners here far exceeds, I believe, the profit or revenue basis that the applicant is going to receive for this property. We've already heard testimony about the potential fire hazard, and as we've talked about, removing the wetlands all the trees, resulting in even higher fire hazard as we move further and further into drier conditions. This is a potential hazard to life and safety and health. It's dangerous. And that needs to be deeply considered, especially in light of the fact that this entire property can be developed into multi-unit housing. It's stated as R1 infrastructure. You put multi-unit housing here. What are the consequences to that to the people who buy into this property, the downstream residents? So again, I would urge the commissioners to look at the global potential cost to taxpayers and homeowners in this area, the risk to life and property, and also the correct interpretation of Goal 5 based on to apply or not apply Goal 5 based on how Goal 5 is written. Thank you. And your own mission statement having to do with preserving the livability of Eugene for future generations. Thank you.
Thank you. Deanna, before you begin, let me just go ahead and get the next person. Sherman Terry, you're going to be promoted to panelist. You will speak after Deanna. Deanna, you may begin. Your time will start when you begin speaking.
Thank you, Crystal. My name is Deanna Kosaraju. I live at 3305 Videra Drive. I'm strongly opposed to the proposed development on Videra Oak Meadow. I understand that no new evidence can be added at this stage of the appeal. However, I want to reiterate my concerns about traffic safety and emergency evacuation were part of my testimony last August and are already part of the record. These issues remain critical and deserve the Planning Commission's full consideration. As one of the few homeowners adjacent to Hawkins Drive, I have firsthand knowledge of the traffic challenges this road faces. Hawkins is a 2-lane road that winds up the hill, creating natural bottlenecks that are already difficult to navigate during peak traffic hours. Adding up to 160 housing units plus 3 people each to this area would significantly worsen congestion and further strain the infrastructure. This also raises serious concerns about public safety in the event of an emergency, particularly given the area's proximity to forests and dense vegetation that increases wildfire risks. In emergencies like the devastating fires recently experienced in Hawaii and California, swift and efficient evacuation routes are critical to saving lives. This proposed development would jeopardize our community's ability to respond effectively in such scenarios. I agree with the thoughtful perspectives shared by Councilman Groves and Julie, who have emphasized the importance of prioritizing safety and ensuring the community's concerns are heard. Their points resonate strongly with the realities we face living in this area. The City of Eugene's own regulations highlight the importance of addressing traffic and safety concerns for developments of this scale. The traffic impact analysis is required to ensure the project does not degrade the level of service on local roads, and such an analysis must account for emergency evacuation scenarios. This is not just a procedural step, it's essential to protecting lives. I'm also deeply concerned about the planning office's recommendation to overturn the hearing official's decision. That decision was based on thorough review of the facts and community input, including my own testimony. Overturning it now would disregard these carefully considered concerns and undermine the trust of the community. As residents, we are not opposed to growth, but we are asking for responsible development that prioritizes safety, respects infrastructure limits, and aligns with these values. This proposal does not meet those standards, and I strongly urge the Planning Commission to uphold the hearings official's denial. Thank you for your consideration.
Sorry, bear with me. I accidentally just depromoted Commissioner Beeson. My apologies. Okay. Chairman, before you begin, please let me go ahead and promote the next person who will be speaking after you. D. Killian, I'm promoting you to panelist now. Please do not turn on your video, however, until it is your turn to speak. And Sherman, you may begin your testimony. I will begin the clock when you begin speaking. Oh, you are muted.
How's that?
There we go. Okay, your time begins now.
Okay, my name is Sherman Terry. I live at 2909 Blacktail Drive, and I'm right near the development. I've been a developer for 12 years, and in real estate for 30 years. And this development is a poor choice for a property developed with all the wetlands. And I think the goal 5 and the maps that they're using are incorrect. And I think the city is going to be liable for a lot of problems with Videra and the flooding it can cause because of this development. And I think it's something we should really consider of how this is going to affect the community. I know you guys are volunteers and you just look at the check boxes and it looks good and you pass forward, but this is a bad idea. And that's the reason there's 75, 100 people that we're all against it. We don't mind a regular development, but middle housing in that area would be a catastrophe. And so I hope you'll consider really looking at these issues beyond what the attorney for them is trying to show you, and talk about how the city has made wrong decisions and courts and everything else. He's just trying to push his narrative. And I think it's really important you look at what's important for the citizens of our town, not for the developer. And that's all I have to say.
Okay. D. Killian, before you begin, let me go ahead and promote the next person. Sheila Smith, you're getting a request now to promote to panelist. And D. Killian, you may begin. The clock will start as you speak.
Hi, I don't think I can say anything much better than what a number of people have already said with regards to this development. I think that the LA fires have made a perfect example for us about the dangers of having not through streets, narrow streets, all of the things that this developer is proposing. And I reiterate everything everybody else has said. My name is Deborah Killian. I live at 2525 Blacktail Drive. I am vehemently opposed to this for numerous reasons. And I'm very concerned about this, the rumor that the city is encouraging the hearings official to reverse his initial ruling, because I have seen nothing addressed that was expressed to concern in the last meeting by the developer, and they seem to be thinking that they have the upper hand and they can pretty much do what they want. And I also think the city needs to look at the Goal 5 issues, because the loopholes are ridiculous, because the whole purpose of the Goal 5 is to save land and trees and riparian habitats and all of those things. And to have loopholes is defeating the whole purpose of what Goal 5 stands for. And I think that's probably pretty much it for me. Thank you very much for allowing me to say my piece.
Thank you. Okay, Sheila, before you begin, I'm going to promote the next person. In the Zoom attendee list, it's just listed as House. I'm promoting you to panelist next. Okay, Sheila, we are ready for you. You may begin. Your time starts when you begin speaking.
Can you hear me okay?
Yes, we can hear you.
Okay. My camera, I can't get it to come on. I'm so sorry.
That's okay.
Yes, actually, I came here to, my name is Sheila Smith. I live at 3325 Videra Drive. And I came here to object to this appeal. And Larry Smith and I had developed some of this material together, and he didn't get to speak near long enough. So can we enable him? Is he allowed to speak for me now to share what we had developed together for my 3 minutes?
I'm sorry, give me one moment.
I'm sorry, Sheila. That's
let me just.
This is Sheila's time to provide testimony. Larry, I apologize. It's not an opportunity to grant you an additional 3 minutes.
I'm sorry. What did you just say?
So Sheila, this is your time to speak. Larry has had his time, and in fairness with everybody else, you are allowed to speak, but we will not give Larry another opportunity.
Okay, well, he's here with me, so I guess the main thing that we wanted that I guess I'll speak to, which I don't have near the depth that he does, but the detention facility that's proposed, just looking at it makes no sense whatsoever. As it currently is proposed, it's one 24-inch pipe, and even back in 2003, even if the wetlands were left intact, it was assumed that at that point that it would take, you know, 8 times that amount. And now, as it's been further developed, or I should say researched, that it's 80 times that amount that's needed for the detention facility scale to meet the needs of the majority of the wetlands if they're going to be removed as is currently proposed in this development program. And that could have massive consequences if that's not the case, if it's not done, because we're downstream. We know what's downhill. It could be a matter of life and death for us and so many of our neighbors, and that has to be taken into account. Our lives have meaning, so please take this into consideration. That right now it cannot be built big enough to transfer the wetlands without this. I'm sorry. Yeah, without dedicating the property that's part of the development. It has to be done. So please, as part of the subdivision, please take that under consideration and realize that we're all neighbors. We're not trying to stop people from building homes, but they've got
30 seconds.
Thank you. I appreciate y'all taking this under consideration. Yeah, and just use some common sense, you know, and do what your heart says, because this is our lives for so many of us. It's going to be, the fear factor is great, and it will be growing. Thank you.
Thank you. Okay. And let's see. And it looks like the Zoom attendee house, you did not accept the panelist invite, so I'm sending a new one. Please hold your testimony quite yet. Chris Butler, you are next. I'm going to send you an invite to promote to panelist. Okay. And House, you may begin. Your time starts when you begin speaking.
Hello, my name is Ryan Esgate. I'm at 3174 Blacktail Drive. I know very little about what y'all are all talking about, other than I love walking down to Oak Meadow regularly. My impression, or I joined this hearing to, you know, get a feel of what everybody is talking about. I'm coming in here completely blind, and I'm glad that we have some experts who know what they're talking about. I really just want to say that the issue list that was presented seems like a handful of gotchas. It's clear that nobody wants this. And these are all like reaches at something like, oh, okay, maybe we can turn this corner here, but like, it's not a good reason. The applicant is telling the commission what their options are for decisions and threatening them with trying to pursue other avenues if they don't work their way. And that's all silly. That's all I've got to say.
Just to be clear, you're relinquishing the rest of your time. Is that correct?
Yep.
Okay, thank you. Okay. Chris Butler, before you begin, let me go ahead and promote the next person. Tom, I'm sending you an invite now. You will be speaking after Chris. Chris, you may begin, and your time starts when you begin speaking.
Hi, my name is Chris Butler. I live at 3234 Jayhawk Court. I want to say that I'm in opposition to the development as it currently stands and completely support the hearing officers, the hearing officials' findings. And what I don't really have much to add to everybody. I'm just curious, so the people that are out here could know, is how many people have attended that are not staff members? And of those people, what percentage, and maybe they could, when we're done talking of the open period, if people could raise their hand again and if they're in opposition to the development as it is currently being proposed and in favor of keeping the hearing officials' findings. Is that possible?
Thank you for the request, but that's not something that we can facilitate through this public hearing and quasi-judicial process.
Can you tell me how many people have attended the meeting that aren't staff? Or at least I can count the staff people, I guess, and the commissioners and subtract it.
I can tell you the number has fluctuated between 100 and 130 people that have been viewing this live webinar. That doesn't mean that people aren't watching from home or on TV and other viewing platforms as well.
Okay. Hey, just my final comment is the impact of the commission's decision on this development as it is going to have long-term impact. You know, people say, hey, Oregon doesn't, you know, has lots of rain. Well, anybody who's lived here in the summer knows that it's not true. You know, the holiday fire turned its on a head with the winds coming from the different direction. We need to make sure we address things like that, the access, the egress, the value of the native oaks that provide. They don't burn as fast as the Douglas firs in a lot of parts. So this would be an area that actually, if left as is, would be protected, less chance of fire, especially with the wetlands that soak up a lot of the water that's here too. So there's a lot to consider, not just in the near term, does it go up in the next 5 years, but how about the next 10 years, 15 years, 20 years down the road? Once again, I'd like to just say that I'm in opposition to the development as is, and completely agree with the hearing officials' findings. Thank you very much.
Tom, you're up next to speak. Let me go ahead and promote the last person who has their hand raised. 2 panelists. Oh, and we have a couple more. Okay. All right. Tom, you may begin. Your time will start when you begin speaking.
Great. Okay, my name's Tom Shaw, 3318 Videra. I am strongly opposed to the project, and I am totally in favor of supporting the hearing officer and all of his findings. I'll make it really quick. Live downhill from the development, and there's a creek that goes through my property 365 days of the year. During the winter, that creek almost overflows. I've had to support it with concrete to make sure that it doesn't erode my property. And this is without any development. Put that development there, that creek will overflow. It will erode my property, remove my deck, possibly my house. Simple as that. The consequences are dire. I've done all that I can right now. And if you read Larry's testimony, he'll give details in terms of what he proposed in terms of wetlands mitigation and so forth. I am not opposed development. I am not a NIMBY, but I feel that this development is completely wrong. Please take a look at what water erosion will do if you put that development in. Thank you.
Thank you. We've had a couple more hands come into that, so I'm going to, before we allow, so sorry, it just says iPhone. Before you speak, let me go ahead and promote the next person, Randall. Okay, and then the person who's in the Zoom attendee is iPhone. You are now allowed to speak. Your time begins when you begin speaking, and you are currently muted.
Can you hear me now?
We can, yes.
Hi, my name is Litton Reed. I live at 3300 Hawkins Lane, directly across Hawkins Lane from the proposed development site. My property is 10 acres, nearly the size as the proposed site. And much of the stormwater that currently exits the proposed site travels through my property initially before continuing on through the Videra neighborhood HOA. I oppose the appeal and support the hearing officials' initial findings based on the fact that this proposal is very irresponsible for the developer to try to push through just a terrible plan, an absolutely terrible plan, and it does not take into consideration so many factors, all mentioned here already by many other people, including tree preservation, clearly stormwater management, ingress, egress, public streets versus private streets. It's just a terrible plan. So with that, I will close and say I oppose the appeal and hope that the commissioners take careful consideration of the impact on the landscape and the surrounding community. Thank you.
Thank you. Okay, Randall, before you begin, I'm going to promote the next person, June Lee. Okay, Randall, you may begin. Your time starts when you begin speaking.
Yes, hello. Is it working?
Yes, we can hear you.
All right. My name is Randall Hopkins. I live at 2760 Hawkins Lane, which is pretty close by to this proposed development. I want to say I support the hearing official's decision to deny the permit. I don't think the planning office should degrade our safety and environmental standards and go against what the hearing official's decision was. It's not correct that Goal 5 label could be the entire area. We need to revisit that and look at that. There's no way it could be. The lot is above the 901-foot elevation. It's steep, and it's only logical that geotechnical testing codes should be applied. I'm not in favor of this development. This is a greenway and a wetland, and we need to preserve it. And that's all I have.
Okay, thank you. Does that mean you were relinquishing the rest of your time?
Yes, thank you.
Okay, thank you. Okay. June Lee, before you begin, I'm going to promote the next person, Douglas Herman. You'll be receiving an invite to panelists here shortly. And June Lee, we are ready for you when you would like to begin, and my apologies if I mispronounced your name. You are muted. I'm so sorry.
Yeah, that's correct. Thank you very much.
Thank you.
My name is June Lee. I live in 3133 Blacktail Drive. As a longtime resident of this community, I have been living here for since 2008, about 17 years. I must express my deep appreciation for the vision behind the proposed development of 160 housing units in our neighborhood. The idea of transforming our quiet, narrow roads into clogged thoroughfares filled with endless traffic sounds like a remarkable way to test our patience and infrastructure resilience. The increased fire risks due to overcrowding and poor emergency access, truly a bold strategy. Nothing strengthens a community like collectively wondering how emergency services will reach us in times of crisis. And, of course, let's not overlook the benefits of stripping away the ecosystem that many of us value so deeply. Removing trees, displacing wildlife, and disrupting natural habitats will undoubtedly create a barren yet efficient landscape for this ambitious project. While I admire the creativity and audacity of this proposal, I must firmly state my opposition to this development. It poses significant safety risks, threatens the local environment, and will irreparably harm the character of our neighborhood. I urge decision makers to deny this project and prioritize the long-term well-being of our community over short-term gains. Yeah, that's all.
Thank you. And Douglas Herman, if you are still on the Zoom, I'm attempting to promote you to panelist again, so you may begin your testimony. Looks like you're in. We will go ahead and begin your time when you begin speaking.
Okay. Can you see me and hear me?
We can, yes.
Thank you. I appreciate the transparency of the commission and this whole process. I'm Doug Herman. I'm at 2298 McLean Boulevard, Eugene, 97405. I have a dog also. No, I'm just I was struck by the intro from reference to the Kalapuya Nation, and I appreciate that. But I just stand in opposition because of the problems with fire prevention, traffic access, wetlands, water runoff, and geological conditions. And I don't have much more to offer, except that whenever I was a public educator for 40 some years here in Eugene, and I would sit in meetings in which we would talk about problems that happened to kids or events that happened. And I want to remind the commission that when the consequences of your decision tonight, like fire, flood, traffic congestion, earthquake damage, come up, and the community asks you what you did to help mitigate or prevent them, I hope you'll be ready to answer in the affirmative about this development and not allow it to go forward. Once again, Doug Herman on McLean Boulevard in Eugene. Thank you so much for my input.
Thank you. We do not have any more speakers in the queue. I'm going to give just a minute here in case anybody thought they had their hand raised, but maybe did not get it there. And it looks like that concludes our list of speakers for tonight.
Well, thank you everyone for taking the time out of your evening to share your thoughts with us. Does the staff have any comments or response at this time to any of the testimony? Nick?
Yeah, thank you, Chairman. Yeah, I just want to say thank you to everybody who participated tonight. Very important aspect of all of this, whether it's a hearings official or planning commission, is the people have to say. So we appreciate everyone taking time out to do this. I know in a lot of ways, some of this stuff is very frustrating for some of you, and I've spoken to some of you, and so I appreciate the comments and I appreciate the civility that we've heard tonight. Thing I want to add is that I sent you all testimony that had come in up to about 1 o'clock today, and more testimony has been coming in, and so we're going to batch that and get that to you tomorrow morning. So I just wanted you to all be aware, and some people are still sending stuff in, so I just wanted to let everyone know that I'm receiving your testimony and haven't been able to respond to anybody because I've been trying to take notes during this process. Thank you.
Commissioner Lear, you're muted.
Appreciate that. Thank you. Do commissioners have any questions of staff at this point? And keep in mind, there will be an opportunity to ask questions of staff following close of the hearing later tonight for any items that may be needed for follow-up during deliberations. Commissioner Edwards?
Thanks, Commissioner Lear. I think you may have just answered my question. I was just curious to know when the record was, when we were expected to close the record, just to know how much more testimony to expect. So that's my question.
I can let If there's a staff member to address that.
I'll just jump in. Commissioner Edwards, at this point, if there are no further questions from commissioners of staff, just clarifying or in response to some of the testimony we've got, I anticipate we'll be closing the public hearing and potentially the record after we hear applicant's final rebuttal, right? So that'll be the next step. So Bill Close, I presume, will be up next for rebuttal, and then we can get to commissioner questions leading into deliberations for next week.
Commissioner Isaacson?
Yeah, I just had a quick question about the wetlands. It was mentioned there was 3.1 acres is what the property consists of. And I'm wondering if, do we know what kind of wetlands they are, or if they're marsh, forested, grassland? What is that? Was that part of the record?
I will say my understanding is that they do have information about the wetland delineation that was done on behalf of the applicant. I don't have the numbers in terms of acreage or precise details about the type of habitat. I know it's in there somewhere in the record, though, within the applicant's materials, or I'm pretty confident that it is. And similar to questions that might come later, that's something we can definitely follow up and bring back. Hard to answer on the fly, but.
Sure, and this might be I don't know if this gets us off the scope of quasi judicial, but has the Eugene Wetland Bank opened back up for mitigation, which would be kind of contingent on this?
My understanding is that the wetland mitigation bank has not necessarily closed, but that we did use up all the credits, so to speak. And so I know, at least in the last few years, city staff through Public Works, and again, this is a little outside the record, so I want to just be brief here. They're working on building credits. It's really on the applicant to determine, and obtain the permitting for that mitigation. It's kind of a technical issue, but I do believe that the city's working on getting local credits, but applicants have been able to go elsewhere throughout the state to purchase credits. So I'll leave it at that.
Yeah, the only reason I ask, and again, you're welcome to come back and say, we looked at this, it's outside the bounds, call flag on the play. But if we're talking about forested credits, there are no forested credits in Oregon. So that could be a huge problem. So I don't know if that's part of the record. If it is, then that's a conversation that we need to have as well. So put it out there.
Yeah, and I appreciate that very much. I think while we might have some information in the record about the type of habitat, I do think it's outside the scope of the appeal issues that are before us. So I just wanted to maybe preempt what Lauren was going to say. Follow me with that. But I appreciate your comment and question. So thank you.
Jump into the mix. Curious if a staff member could speak as to the, call it, evolving position on Randy Lane's status as a public versus private road during the process, and maybe provide a little bit more detail about that.
And you want that now?
It could be next week if that would be better.
I'd appreciate having a little time to articulate that rather than addressing it on the fly. I know there were some issues that came up in the initial hearings process that caused us to look back at that question, partly due to the street connectivity exception and the fact that Randy Lane is a public street at the top of the hill. And there was a desire for a through connection there, but we'll come back with a more complete and robust discussion on that appeal issue, I'm sure. So
sounds good. Any other commissioners with questions currently? Well, now is the opportunity for the applicant to present any final statements or rebuttal. Applicant, will it be Mr. Close?
Yes, and bear with me. Bill, I am sending you an invite to be promoted here in a moment. I do want to also note that we cannot allow additional testimony from anyone at this point. So Carrie, I saw that your hand was up and I just wanted to address that we see it, but testimony has closed for that. We are in the applicant rebuttal period.
This is Bill Close. I'm back. Can you see me or do you see my wall?
We do not see your video at all. but we can hear you. So.
Okay, good. Well, let's get that fixed by Ellie. You're up. There we go. Yeah, I got a balky.
I did just want to clarify real quick, Crystal. So are we limiting this to 3 minutes? Was that kind of the understanding from the beginning of the conversation, or is this an untimed response?
Thank
Just
you
to make
for the
sure it's
question,
clear.
Commissioner Lair. Thank you for the question. No, because, and I might have misspoken earlier, in this case, the appellant is the applicant, but in these types of appeals, the appellant, who has the burden of proving their case, is given additional time at the beginning to make their initial statement, and then, as Gabe mentioned, unlimited time for a final statement / rebuttal of issues that may have come up during the public hearing.
Thank you for the clarification.
Bill, you can take it away and we can see you as well. So.
Oh, thank you. You got everything I have to offer. I will be brief because it's almost my bedtime. I have my short shopping list of issues here I want to respond to, starting with the question about wetlands. And I agree this may not be relevant, but there are wetlands on the site that are not proposed to be filled. And if you look at the site plan, which shows up in several places, including page 32, PDF 32 of the staff report, the site plan shows the wetlands that are not going to be touched. And those are all shown in dark shaded blue. A fair amount of them, I forget the acreage, but that's where those are. And yes, the applicant has reserved mitigation credits from the, I believe it's Eugene Wetland Mitigation Bank. So that's the current status for the wetlands that he proposes to fill, assuming he gets the final green light from the DSL to fill those wetlands, consistent with the site plan that you have in front of you. Randy Lane public road status. Great. Staff can address this in the next staff report. The two key things several things I want you to keep in mind. The most important is Randy Lane cannot be connected through because of the steepness of the topography. I think in the back of the Public Works minds, they're thinking, well, the standards are going to change and we're going to allow steeper streets and we're all going to get a new set of fire engines. So it's all going to work out. So, you know, we want it to be public now so that we've got something to connect through. It's never going to be connected. That's the current reality because of its topography. And the second thing is, it's the street, the private road part that we have to build is the private street with the least number of units on it. And the city seems to be just fine with the other two streets being private. General point with respect to the scope of the issues that are before you. A lot of issues have been brought up tonight that are not in the list of 10 issues that are on appeal. The commission is, I'm sure staff will advise you of this, but the only issues that can be considered by the commission are the issues that are in the appeal statement. If the neighbors wanted to have issues considered, they needed to file their own appeal. That point is made very clearly in one of my favorite LUBA cases, Treadmill Joint Venture versus City of Eugene, 65 or LUBA 213, 2012. I think my client, the housing developer who named that entity, Treadmill Joint Venture, was a little frustrated with his efforts to get regulatory approvals. But that's what LUBA said in that instance. In that case, the Planning Commission, your predecessor, addressed the issues in our appeal to the Planning Commission, resolved in our favor, but then as our car was leaving the Planning Commission venue, the Planning Commission broke the rear windshield by adding a couple issues of their own. And so LUBA clarified in this decision that the only issues on the table are the ones in the appeal statement. Nobody can add any more issues to the list, including the Planning Commission. That's the way the code reads. I want to express my concurrence with Randy Grove's statement about the importance of fire, particularly in the South Hills. I've been saying this for 40 years because I've done a lot of PDs and developments in the South Hills, and the emphasis has always been on houses first, or trees first, houses and people second. It's a little simplistic, but you look at the South Hills and it's dense with vegetation. And I agree, the whole area is a huge fire hazard, and we're all more aware of that now by watching CNN. The particular question about width of pavement on private streets and whether or not there can be parking on one side, that's a great policy question for the city to chew on. The current standard is outlined in the city's own design standards and guidelines for Eugene streets, sidewalks, bikeways, and access ways, 1999 at page 35, table 2. It says you can have parking on one side of a street that's proposed to be this wide. Can that be changed? I think it can, unless there's some state law that says otherwise. But it's a policy issue for the city, and all we're doing is following, our proposal simply follows the rules. There was a reference to this project having 160 housing units. That's not right. It's 39 lots, which is being reduced to 38 lots because 37 and 38 are being combined, and the city won't let us put anything on 39. These lots are all laid out for a standard single-family dwelling, just like everything completely surrounding this site. This is an infill project. How do people get to the number 160? Is because my client and this site are victims of the middle housing statute, just like everybody else. There's nothing my client can do to limit this project to 37 to 38 units. State law now prohibits it. That's the middle housing statute. So any one of these lots that's bought by any person, that person walks in, they have a right to do a single family, duplex, triplex, or quad. That's it. It's just the reality. That's how the state intends, with its big dull axe called the middle housing statute. That's how the state intends that we're going to get more housing. So people say 160 units. My client's thinking 37 units. Charles Woodward made the appropriate remarks about Goal 5 inventories in Eugene. It is very difficult to figure out what is the acknowledged Goal 5 planning documents. I mean, Luba said this very directly when my clients, the home builders, in 2001, challenged the new Eugene zoning code, the zoning code that we use and enjoy right now, land use code update. There were two parts to that appeal, which resulted in an 80-page Luba decision. Half of that appeal challenged compliance with Goal 5, and the other half challenged whether the standards were clear and objective for housing. And Luba had to get into and figure out how you figure out what is the definitive mapping of acknowledged Goal 5 resources, including scenic areas and so on. And Luba was very candid. They said, this is really hard to figure out. And they went on from there. They did say that when it comes to scenic areas, this figure H2, which staff says that's our best shot at what's the acknowledged Goal 5 map, Luba reached the same conclusion. Am I still confused about it personally? Yes. Do opponents, Lloyd Hellickson included, make good points about the covenants of the acknowledgement process conducted by LCDC back in 1982 on this issue was suspect? I have to agree with that. I mean, it's very hard to track, and the analysis wasn't good back then in the old days. But in the final analysis, the question is, what was acknowledged? Not whether it was done right, but what was acknowledged. And my sense at the end of this process is staff got it right when they said, basically agreed with Luba that when it comes to scenic areas, you look to map H2. My client is, a lot of folks testified. A lot of them are raising valid concerns, good points, respectful people. My client and this site have problems that are typical with infill sites, because this site, for example, is the last 15-acre chunk of an 80-acre plan unit development that a former owner had approved in 1999. I did that initial PUD application for the entire 80 acres when it was owned by the Cutterback several owners back. And there was opposition then. The same kind of points were being raised, but things are particularly acute now because this is the last 15 acres. But that said, the site is still planned and zoned for single family development. And that's what we're proposing. Another opponent added a map that shows the 5 or 6 various site plans that have been approved for this site since 1999. And he says, well, what's up? They can never get it right. And it's true in a way, but when you look at the reality of what the various owners have faced, over the 20 years, we've had a series of amendments to the standards for getting housing approvals. You know, the code we have right now for PUDs on this site is very different from the code that we had in 1999, extremely different. And, you know, so each owner comes along and looks at the code and looks at the site and says, well, what would work best here? And a new application is filed. So we wind up getting a stack of different site plans. That doesn't mean that my person's not doing a good job. My person gets a team and comes up with a site plan that he thinks works best for the site. I agree with Charles Woodward. He agrees with me that resolving the major issue here, which is a relationship between the middle housing statute and the restrictions that are in the PD overlay zone, resolving that question requires looking at the statute and construing it or interpreting it by applying the rules that are set out by the Supreme Court in the PG&E case for doing that kind of work. And Mr. Woodward said the same thing. And he said that he offered his own PEG analysis. He did the homework assignment, and he came up with a different meaning than we did. You know, so bless him for taking a crack at it. That's an honest effort. The only people that haven't done the homework assignment is the planning director, and I'm just confounded by that. I mean, it's no surprise to the city that that's the obligation for interpreting the statute. Luba reminded the city of that in 3 successive decisions remanding the director's code interpretation, their zone verification letters in the Camp Hughes matter. You know, one guy, one lot, alley access, infill, give me an ADU consistent with the new statute. 3 times the city said no, and 3 times Luba said, you got it wrong. You got to apply the statute directly over the code. You got to understand what the statute says. You apply the PEG rules for interpreting the statute. That's what we're going to do here, and you're wrong. And my position to the Planning Commission is, there they go again, as Ronald Reagan would say. And we've tried to make it easy for the city by giving them a new zone verification application on behalf of the home builders, filed on December 28th, 2023, which would require give the planning director an opportunity to do a PG analysis of this issue, relationship in the middle housing statute to the 901 restriction in its PD overlay zone. And if the director had done that anytime early on in the 14 months that it's been sitting there percolating somewhere in the planning department, if the planning director had done that anytime early in that process, we could have taken an adverse decision, what we would consider a bad interpretation of the statute. We could have taken it to Luba, and Luba would say, here's how you do this. We're going to do exactly what we did in Camp Hughes. We're going to apply the PG rules for interpreting the statute in relation to your PD overlay zone 901-foot restriction. And here's the answer. And then that answer would be defining, it would be resolving the one major issue left in this case. But we couldn't even get a decision from the planning director in 14 months on a specific application. Why not? Which all gets me down to my final point, which is I suggested there were three things, the three approaches you could take to handling this interpretation issue on the middle housing statute. That is, just adopt our interpretation. I can understand how you might be reticent to do that because you haven't heard from the planning director. You haven't seen a PG analysis by anyone at the city. So the second thing you could do is you could turn to the planning director and say, hey, would you please complete the homework assignment? Ask your attorney to do a PG analysis of this legal question and give us the answer. You know, we've got other things to do in the meantime. Take your time. Don't take a year. Don't take 14 months. But give it a shot. I mean, Mr. Close did it for the applicant. Mr. Woodward did it for the opponents. Say something other than we're right. Our code applies. I mean, really what the director has done here is they just taken the position our code standard applies, and they've stuck with it. They haven't explained it. I mean, people that do what I do in the city of Eugene sometimes refer to this strategy as the squatting elephant. You just take a position and you sit down, you don't budge. And so far, that's what we have from the director on the crankshaft issue in this application. So I would recommend you consider option 2 in my list. It's a heck of a lot better than option 3, which is just get on board and take a position that the director's taking, because the director has to always be right about these things, and resolve it that way. That's it. That wraps it up for me. Thank you very much. I appreciate your long suffering. I always talk more than I expect to, but it's the way it is. Thank you.
Thank you. The Planning Commission public hearing is closed. And unless I hear objections from other planning commissioners, I will now close the record. Any objections? The record is now closed. Do commissioners have any questions or requests for more information from staff that would help facilitate deliberations at our next meeting? Keep in mind the staff may not have immediate answers, but are ready to take your questions and bring back information for deliberations next week. Commissioner Beeson?
Thanks. A couple of things. I want to say thank you to everyone who spoke to us tonight. Clearly, this has been going on quite a while. I think I've found myself immersed in it about a week ago and have been going through this material. There's a substantial amount of it. I'm continuing to go through it, taking a bunch of notes tonight. There's a number of things to continue learning about and digesting. And generally keeping in mind, want to stay within the record, considering the appeal issues that have come up on the hearing's official decision. But there's a lot here to consider. I would want to echo, I'm not looking for any answer tonight. I get that. I do want to echo, I guess, any request or what I think Gabe was saying. You guys would come. The whole idea of Randy Lane and the public street and the private street and the width, the standards it's developed to. I got into that a ways, and I find myself wanting to go back and review the Public Works material that was referenced in there, where they opined about, I guess, the adequacy of it and so on. But I think anything you guys can bring back based on what we've heard tonight that would kind of help get us focused on that. I kind of appreciated hearing from Councilor Groves on that. A question, and maybe I should know, I also know from having done this for a number of different times over the years, I'm not supposed to drive out there. So I didn't drive out there. I say to Lauren and all of you. Is Randy Lane on the west side of this? I'm staring at the plot plan here. And on the west side, there's this stub of Randy Lane that comes in there that's labeled public street. That doesn't exist today, does it? Or does it? Or
I'll jump in and say, if Commissioner Beeson, if you're referring to the applicant site plan and the western segment of Randy Lane that exists today and connects to Blacktail Drive, there isn't an existing intersection there that is public.
Okay.
And you may then see, as you move east, there is a missing section of the street, not yet developed or connected. Right. And that missing section, if you will, is really the subject of this conversation.
Okay.
The existing portion of Randy Lane that stubs in on the east side of the property at the top of the hill is also public. Right. So you have.
Yeah, right on the east side there, but that portion there coming off the portion that's labeled public street, then it's labeled private street. That's the part we're talking about.
Right. So as just an initial indication, part of the reasoning, I think, around the evolution of all this is that you've got two public streets pointing at each other, and the standards call for that to be connected as such. Now we have the slope issue that kind of comes into play, and we'll come back with plenty more information to kind of tease all that out for you.
Yeah, I understand it won't be connected and can't be based on current standards and so on, but I'm okay. That helps. Also, I want to, I've spent time, as probably everybody has, looking at the Goal 5 question and all of the kind of the interpretation of that. I'm finding myself wanting to hear back, I guess, from staff at least a little bit on your confidence. I can use the word that way. Your confidence that Goal 5 covers all this property. I guess I'm hearing that you're pretty confident. A couple of times as you talk about, I mean, I get the idea when we're talking about a map at that size scale, and then coming in and trying to find this 15-acre plot there. I think just kind of double checking. I'd like to hear from you guys about a little more about that. I'm definitely going to have some more questions, I think, as we go through this week and I work on this some more. I think there'll be I'm going to get additional material. So I'm expecting as we start the deliberations process next week, we'll probably want to have some time for questions there. So again, I guess I mainly also just wanted to say thank you and appreciation to the people who testified tonight. I think I understand. I think I understand. There's people are pretty focused on this. They've been working on it for a number of years. I think this has clearly been around for a while. And we're, as you understand, I think as you've heard, we're confined to looking at the direct issue of the hearing's official report and the appeals issues here and making some determination based on that. So that's what we'll do. Thank you.
Thank you, Commissioner Beeson. Any other questions or comments from other commissioners? Being none, the public hearing and record for this appeal are now closed. Deliberations are scheduled for Tuesday, January 21st from 5:30 to 7:30 p.m. and Tuesday, January 28th from 5:30 to 7:30 p.m. You can watch deliberations by visiting the Eugene Planning Commission website where live broadcast will stream. You can also watch deliberations using the meeting and materials and webcast link from the main City of Eugene website. If you have questions about viewing the deliberations, please reach out to Nick. And the meeting of the Planning Commission is now adjourned.